Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today, we will explore the landmark decision of the Supreme Court of India delivered on 31st October 2025. The Supreme Court of India, in its landmark judgment titled, In Re, Summoning of Advocates Who Give Legal Opinions or Represent Clients During Investigation of Cases and Related Issues, delivered on 31st October 2025, has given clear and strong directions to protect advocates from unnecessary harassment by investigating agencies. This case, registered as Suo Motu Writ Petition, Criminal, No. 2 of 2025, and heard together with Writ Petition, Civil, No. 632 of 2025 and Special Leave Petition, Criminal, No. 9334 of 2025, was decided by a three-judge bench comprising Honorable Chief Justice B.R. Gavai, Justice K. Vinod Chandran, and Justice N.V. Anjaria. The bench made it clear that lawyers cannot be summoned or pressured merely for performing their professional duties such as giving legal advice or appearing for clients. It reaffirmed the protection given under Section 132 of the Bharatiya Sakshya Adhiniyam, 2023, BSA, which safeguards the confidential communication between lawyer and client. This judgment, cited as 2025 INSC 1275, strengthens the constitutional rights of advocates and upholds the dignity and independence of the legal profession in India. 1. Background. In recent times, there were several instances where investigating agencies, police, enforcement directorate, etc., issued summons to advocates simply because they had given legal advice or represented clients in court. This raised serious concerns about the independence of the bar and the confidentiality of legal advice. In this context, the court Suo Motu took up the matter and issued its decision clarifying how Section 132 of the BSA must be interpreted and applied. 2. What Section 132 of the BSA provides. Section 132 of the BSA is the statutory codification of the advocate-client privilege. It states that no advocate shall, without his client's express consent, disclose any communication made to him in the course and for the purpose of his professional employment. The privilege persists even after the professional relationship ends, once privileged, always privileged. However, the BSA provides limited exceptions. Communications are not protected if 1. They were made in furtherance of an illegal purpose. 2. The advocate observes facts in the course of his employment that a crime or fraud has been committed or is about to be committed, or 3. The client consents to disclosure. The court emphasized that this privilege is conferred on the client. The advocate can invoke it on behalf of the client. 3 key directions of the Supreme Court, 31st October 2025. The court gave several specific directions to ensure that privilege and professional independence of advocates are upheld. These include: A. No routine summons of advocates. Investigating officers or station house officers shall not issue a summons to an advocate merely because the advocate represents the accused or gave legal advice, unless the matter falls under one of the exceptions in Section 132. B. Prior written approval and specific grounds. If a summons is to be issued to an advocate under one of the exceptions of Section 132, the summons must explicitly specify the facts and circumstances relied upon, which exception is invoked. There must be prior approval by a superior officer not below the rank of Superintendent of Police or equivalent, who records satisfaction in writing before the summons is issued. C. Judicial review. Any summons issued under these circumstances is subject to judicial review by the High Court or Supreme Court under Section 528 of the Bharatiya Suraksha Sanhita, 2023, BNSS, or corresponding enactment. D. Production of documents and digital devices. The privilege under Section 132 does not extend to production of documents or devices in the advocate's possession. Production may be directed under Section 94 BNSS Section 165 BSA, but the procedure must ensure safeguards. If a digital device is directed to be produced, it must be before the jurisdictional court, not the investigating officer. While examining the device, confidentiality of other clients must not be impaired. The advocate and the party have the right to the assistance of a digital expert of their choice. E. In-house counsel special distinction. The court held that in-house counsel or full-time salaried legal advisors employed by companies are not advocates practicing in courts and hence cannot claim privilege under Section 132 BSA. They may, however, claim limited confidentiality under Section 134 BSA. 4. Practical implications. For advocates, private practice. You cannot be summoned simply for advising or representing a client unless one of the narrow exceptions applies and proper procedural safeguards are followed. You and your client can resist any summons that does not comply with these directions. For investigating agencies and officers. Do not issue summons to advocates unless the Section 132 exception clearly applies. Get prior approval from a senior officer, record written reasons, specify the grounds in the summons, and follow all procedural safeguards if documents or devices are sought. For clients of advocates. Your communications with your advocate are protected except in limited scenarios. If an agency compels disclosure without due process, you and your lawyer can challenge it. For companies and in-house counsel. If you are a salaried in-house lawyer, note that you do not enjoy full privilege under Section 132. Your communications with your employer may not have the same level of protection. 5. Why this judgment matters. It fortifies the independence of the legal profession by preventing misuse of summons to harass advocates. It balances rights and powers, aligning Section 132 BSA with procedural safeguards under law. It gives clear operational guidance to investigators and courts, reducing ambiguity in practice. 6. Key takeaway summary. Privilege. Section 132 BSA protects lawyer-client communications. Summons to advocates, not allowed unless an exception under Section 132 applies. Need prior approval plus written reasons plus clearly stated grounds. Documents devices, only under strict court-supervised process. In-house counsel, no full privilege under Section 132. Judicial review, available under Section 528 BNSS. 7. Conclusion. In conclusion, this ruling is a major step in safeguarding the professional freedom of advocates, protecting the confidentiality of legal advice, and ensuring that investigatory powers are exercised with restraint. As legal professionals, clients, or government officers, this decision clearly defines the boundaries within which we must operate. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.